I think it's interesting, if we'd been sitting here 25 years ago, most of these issues wouldn't have been what we've been talking about in trade. It would have been tariffs and quotas and so on. It's just an example of some of the issues like SOEs and labor really weren't even on the agenda there. Others, investment, were there, but frankly, the investment chapters in most early agreements were sort of things only were on the back of the agreement, and only a few lawyers cared about it. And how it's now, if you believe some of the critics, the investment chapter, or a so-called dreaded investor-state dispute settlement, is the existential threat to everything that's good in the world. I think just shows how things change. Look, for us, the way the world has changed, the global economy, global value chains, global supply chains, investment is more and more important to companies, large and small, if they want to succeed in today's economy. But yet, ironically, global foreign direct investment, FDI, flows are lower now than they were in 2007. There's been a recovery since 2008, but there's still a long way to go. And there are a lot of business reasons and challenges out there, but part of the thing is that intentionally or unintentionally, governments do things that are bad for investors. So I think it's important that there be a strong commitment in the TPP to the value of investment and a way to resolve those things. Now, when the topic for today, for me, is investor-state dispute settlement. As you were saying, Michael, it's really, I think, important to broaden that and talk about the investment chapter. And traditionally, investment agreements, whether it's a bilateral investment treaty or an investment chapter in a free trade agreement, have three provisions. One is the sort of the core protections, non-discrimination, national treatment, most favored nation treatment, protection against expropriation, right to repatriate your capital, and so on like that. The core substantive provisions in the agreement. The second provision in a U.S.-style investment agreement is really the market opening, the so-called negative list, and where each party lays out those sectors that would not be open to foreign investors. And other than that, everything's open. And so European-style investment agreements have typically not included this, but it's been always been important for the U.S. U.S. business community certainly wants that to be included, and it is included in the TPP agreement. And then the third, of course, being an old State Department guy, there's got to be a three-legged stool or something. The third leg of that stool is the enforcement or implementation provision, and that's really where investor-state comes in. And that's where an investor has the right, if they feel they've been treated, that their rights under the investment agreement have been violated, they have the right to go directly to challenge the host government in an independent expert arbitration process. And I think that's, some people say, well, this is why do only investors get this special right? But there are, I mean, every day in U.S. courts, companies, small and large, are going into U.S. courts and filing for compensation for actions of governments. And so this isn't something that's unique to investor agreements. And when an investor kind of leaves their home country and goes and invests, I mean, they really are putting themselves under the legal authority of another sovereign government. So if you have a dispute with that sovereign government, and in some countries, I would say the court system is not sufficiently independent or fact-based and so on, I think it's important to have a way that you can get independent international experts to help settle this thing. As despite the claims of some of the critics, governments win more investor-state cases than they lose. When a company, a claimant, wins, they typically get somewhere around 4 or 5% of the amount that they had claimed. So a lot of the criticism of investor-state dispute settlement is much inflated. But it is, in my view, very important, and I think what we've seen in the investment chapter that's ended up in the TPP is really quite positive. It is to a great extent based on the U.S. model of investment agreements. Includes a lot of transparency provisions where, again, the U.S. is sort of the leading advocate and setting the model for that. Has strong protections for investors and so on. So I think it has, very importantly, a broad definition of investment. This isn't just a physical factory, but intellectual property rights, investment contracts, investment agreements. All of them need to be included, because the ways in which, not just today, but going forward, firms invest, it takes many, many different forms, and so I think that's very important. And then it does have the strong ISDS provisions. There are two areas where, frankly, our association, and I think others in the business community, have registered some concern. One is the fact that the financial services sector was, unfortunately, and not in conformity with the U.S. model bit, sort of carved out from being able to file an investor-state dispute settlement on so-called data localization requirements. And there's a long and complex debate about why that happened or what the implications, but certainly many of us are troubled by that. And then there is also, as has been reported widely, one particular sector has been carved out from having access to the investor-state dispute settlement arbitration process broadly defined, and that's the tobacco sector. And that obviously concerns them, but it's also concerned a lot of other people in the private sector, wondering, once you start this precedent that one sector can be sort of denied this and governments are given, in effect, the right to do whatever. Can they expropriate and not compensate someone because they're on this list of bad sectors? And if so, what other sectors might be next or might be controversial? So those are concerns that we, and I think others in the business community, have urged the administration and the Congress to work on and try to see if there are ways to improve them somewhat as and before the ratification process moves forward. But in general, the TPP investment chapter seems to us to be quite a strong one based on the U.S. model, and we at least will be strongly supporting congressional action to ratify the agreement. Thanks.